Good morning. This is John Callis, President and CEO of Castle Breckenridge Management, La Mesa, California. Today is Monday, November 7th. We're very privileged today to have attorney Laurie Poole from Peters and Freedman, and also President-elect of Community Association Institute, commencing January 2017. Let's give a big hand for Laurie. Today's topic is going to be short-term rentals, which is a very hot topic in communities, planned unit developments, common interest developments throughout the county. And Laurie is going to speak specifically to this topic, and then we will take a few questions. Laurie.
Thank you, and thanks for having me. So short-term rentals are definitely a hot topic today. I know I've been dealing with them with my clients, and I'm sure you all have been dealing with them as well. So why are associations concerned with short-term rentals? What are some of the issues that associations have been facing? Certainly the nuisance factor. Many people, at least that I've been dealing with, that have been coming to your communities to short-term rent, they're not there as living, working people in the community. They're there on vacation. They're there to party and have a good time. And so what does that create for the associations and the neighbors? It creates nuisances. It creates noise issues, parking issues, ignorance of the rules, and maybe even beyond ignorance. They just don't care. They're there to have a good time. They're there on vacation. So it also can result in some long-term damage. There can be damage to the common area. They're not owners. They're not even long-term tenants. So their use of the common area is based on, again, them being there for a short period of time to have a good time. And so we're finding damage is occurring to the common area. There's security concerns, lots of people coming and going, maybe keys to the common area facilities are being handed out left and right, and that raises a lot of concerns for associations. Some associations have also indicated an issue with questions about liability. Does this increase the liability for the association when you have a lot more unknown people coming into the community and using the facilities and maybe creating some hazards or getting hurt themselves? What kind of increased liability? So what can associations do to counter the increase in short-term rentals? And with the big business that short-term rentals are, these websites where it's very easy to post listings for short-term rentals, they're not going away. They're only going to increase. It's big business. A lot of people have indicated that they are able to supplement their income. Some people who had second jobs are able to quit because of the income that they're getting from these short-term rentals. So it's not going away. I think it's only going to increase. And so associations really have to look at what can we do to take care of this, to address this problem. I think the first thing you want to do is you want to check your governing documents. You want to make sure that you have the language in your governing documents to address the issues that are being raised by short-term rentals. You certainly want to have a minimum lease provision in there, commonly requiring tenants to have to rent for at least 30 days or even longer periods of time, maybe 90 days. I've written 12 months, I've seen 24 months. So you certainly want that in your governing documents. You also want language indicating that leases cannot be used for hotel or transient use. So that will also take care of making it clear that these short-term rentals are not allowed in the community. I've also been starting to write provisions saying it's even a violation to list your unit or list your separate interest on a rental website in violation of the CC&Rs. So for instance, if your governing documents say you have to lease for a minimum of 30 days, having a listing that's a weekend rental or a week-long rental, I'm even starting to write that that's a violation in and of itself. You want to also make sure that you have a really strong enforcement policy. Strong and flexible. A lot of times your enforcement policy is written that here's the protocol for a violation. Courtesy letter first, second letter maybe with a hearing and a fine, But you want to have flexibility, because for really egregious situations, or maybe because of the nature of short-term rentals, you want to nip it in the bud. You don't want to maybe have to send a courtesy letter as the first communication. You maybe want that letter to be a cease and desist from legal counsel. I know I've written it a lot as the first line of defense, but the first thing I'm doing is I'm checking that enforcement policy to make sure that the association isn't locked into having to follow a certain protocol. You also want to make sure that you increase the fines for short-term rentals, or even for the listings as well. These people are making a lot of money, and if you have a $25 fine for the first offense, that's not going to hurt. So you want to make sure you have a fine that really hurts, and it's going to impact, it's going to be a disincentive for them to continue to short-term rent. So you can actually have a separate fine schedule for specific to short-term rent violations, or like I said, even including the listing itself as being a violation and a fine. You want to make sure the documents allow you to assess the responsible owner of the unit for costs of compliance, maybe increased administrative costs that associations are facing with management having to get involved in these and spending extra time. You want to make sure that those documents allow the board to get reimbursed for those costs from the owner. I had one recently. I just wrote a cease and desist letter, and I got a call from the owner. She didn't even know this was happening. She has a 2-year tenant in there, and we suspect the tenant is actually the one doing the short-term rentals. But I told her she's the unit owner. She's responsible to make sure that the tenant is complying with the law, with the rules, I mean. You also want to make sure that you have there are other provisions in your documents that can also be enforced against the short-term rental situations. Business use, no business use. These are single-family residential homes. They're zoned for single-family residential use. You want to make sure that you have that in there, and maybe even saying that short-term rentals is deemed to be a business use and therefore violates that provision as well. You also want to have your nuisance provisions in there. Most associations do. I don't think I've seen a set of CC&Rs yet that didn't, but you might even want to specifically say that short-term rental violations are specifically a nuisance as well. Call it out. So some of the challenges that we have. So we know once you have all this in your documents, the next challenge is going to be, how do you enforce the violations? Usually associations are finding out that people are short-term renting because they are getting complaints from the homeowners, from their neighbors. And at that point that the neighbors are complaining to the board, they're fed up. They've been dealing with the parties, they've been dealing with the parking violations, they've been dealing with the trash. They're done. And so they're coming to the board and they want something to happen yesterday to stop this. One of the interesting challenges I'm facing is, and you may all be facing as well, is once you send that letter to the owner and you advise them that they're not allowed to short-term rent, that they're violating the CC&Rs, you start getting the excuses. I've heard some really good ones. My favorite right now is, it was the dog sitter. Yeah, the dog sitter. Interesting that the dog sitter showed up with his husband, wife, 2 kids, and their own dog. I thought that was fascinating, but it was the dog sitter. They're guests, they're family members, they're not short-term renters. That's what you're gonna hear. And proving that they're not is difficult. So brace yourself, because you're gonna get those excuses, and we gotta start looking at how are we gonna actually prove that they are renters and not the dog sitter. Another challenge in enforcing is there's a lengthy enforcement protocol. So unless it's a really severe, egregious situation, most associations are not going to run into court and try to get a temporary restraining order to stop this activity. You're going to follow your enforcement protocol, which does include due process. If you're going to take disciplinary action, you need to give them at least 10 days notice before the hearing. Call them in for a hearing, tell them what you plan to do, and assess whatever disciplinary action. That's going to take time, and it's not necessarily going to stop that rental activity, especially if they've got the next 3 months booked out. So that's a challenge. There's also no legal relationship with the tenants between the association. My story about this, we believe it's this renter who's actually doing the short-term rentals. That's even one step further away from the association. But it is important to impart on the owners that it is their responsibility to take care of this and to make sure that whatever, even if it's their renter that's doing it and they're not aware of it, they're still ultimately responsible. And the cost to enforce. Depending on how far down the path you have to go, it can get costly. Our firm has had 3 cases now that have gone to trial or stipulated judgment. And those attorney's fees, they rack up. The good news is that under the law and under most governing documents, you can seek reimbursement for the attorney's fees. But you need to understand that the association is paying those fees out of pocket to get compliance. And if you go all the way to trial, we're talking about significant fees. And not all judges, I know this is shocking, but not all judges necessarily award the association 100 cents on the dollar for what they spent. They are entitled to look at what was spent in enforcing it and determine the reasonable amount that should be reimbursed by the owner. So how do we prove that these owners are these people are engaging in short-term rentals? One way is to get copies of those listings, those ads, and make sure you get copies of everything. The reviews. We had one where the dog sitter, where there was the picture, it has the host picture, it had his picture with, "Hi, I'm so-and-so." Well, gee, it happened to be the same name as the owner on the short-term renting listing. So that helped us to tell him we didn't believe it was really the dog sitter. Reviews are good too. We had one review often the reviews will talk about how much time they've spent there, maybe a weekend. "Oh, we had a great week, in Scripps Ranch," or whatever. So that's helpful to prove again that they're violating the minimum lease provision. There's also we also had one where in the review they talked about how the rental only had 1 bathroom, so they were using the common area shower. Yeah, it was great, which everybody else is paying for, right? They're all paying for that water, and it was right in the review. So that's good evidence. And you want to make sure that you print it. If one of the owners, it's usually the complaining owner, will send you the link with that listing on the website, you want to make sure you're printing it. You print everything. You print it that day. You print it before you send the letter, because oftentimes when we send that first notice letter, those listings are gone. And they get reconfigured in a way that it makes it harder to find them. So you want to be able to prove that they actually did have that listing. You also are going to need to have witness testimony. The neighbors that were complaining, I often put them to work and tell them to start keeping a log. Keep a journal, keep a log. If they feel comfortable to take pictures, not invading anybody's privacy, you have to kind of walk the line there, but not invading anybody's privacy, to maybe take pictures of people coming and going. That's how we got the dog sitter with his husband, wife, and 2 kids. One of the neighbors took a picture, and just literally ask them to keep a log. When do they see cleaning crews coming and going? When do they see, maybe different people with luggage coming and going? So put them to work. It'll make them feel like, first of all, it's necessary. Second of all, they will understand the association's doing something about it. But ultimately, too, those neighbors may have to testify. And same with board members. If board members have personal knowledge of the short-term rental activity, if they're witnessing it themselves, they're going to have to testify if it ultimately goes to court. The best information, though, on ones that do go through trial is the contact information from the renter. I will tell you that the listings and the complaints from the owners are enough to file a lawsuit. Is it enough to prove a short-term rental situation? Maybe not. But once you do have a lawsuit filed, you can start using the subpoena power of the court to get financial records, to maybe be able to piece together the rental income that they were getting, copies of the leases, things like that. But some of the best evidence that our firm has had in taking these to trial has actually been the deposition testimony of those renters. One man who was here from France for 3 weeks, violating a rental provision, which he didn't know, he got to spend part of his 3-week vacation in a conference room taking a deposition. Yeah. I don't think he was going to rent again from that person. Another one, we found out that we got the renter's contact information. She was a doctor in Chicago. We flew out, took her deposition, and videotaped it and played that for the judge, and that was very compelling testimony. In that case, the owner was saying that she was a friend of his, and she said, I never met the person. I answered an ad on a website and showed up and rented, and that was that. So that was very compelling testimony. How do you get the renter's information, though? It's dicey. It's difficult. You kind of want to be careful of board members going up to these people who are there and starting to ask questions. I had one board that was accused of harassing the family members. They were family members in that case. But I did have a board that was accused of that because every time somebody came in, they were out there and they were asking questions and interrogating them. So it's a fine line. But if you're able to, if you have, if you're in a community where maybe they're coming up and asking where the pool towels are, that's also another indication of short-term renters. And you can say, oh, are you a renter? Oh, we have a registration form. Can you fill it out? I mean, you kind of have to play around with that. And I think from community to community, you might have to figure out how you can get that information. Maybe getting copies of the leases, that kind of thing, that might help. There's a few other tools out there for associations to help with enforcing short-term rentals. Cities that don't allow short-term rentals, and there's been as much activity in HOAs, there's been a lot of activity on the city level. I know San Diego, was it last week, was considering banning short-term rentals. So for those cities that have banned them, they probably have a hotline that you can call. You can get code enforcement. It doesn't necessarily eliminate an association's enforcement, but I always believe the two-pronged approach is better than a one-pronged approach. So if you can get the city on them as well as the association with enough pressure, that owner may get the message and stop short-term renting. There's also some websites, and I put them on the handout, but I haven't actually checked them out myself, but I've seen reference to them, that these are websites that will actually monitor, for a fee, they will monitor your addresses and monitor the rental websites and maybe be able to tell you whether any of the addresses in your communities are being listed on short-term rental websites. Like I said, I haven't tested it out, but I've seen articles written about them. That's where I got the website information from.
Okay.
So that, in a nutshell, is what I know about short-term rentals.
We have a few questions for you, Laurie.
Okay.
Should the rental provision be in the CC&Rs or the rules and regulations?
You know, that's a great question, and I think it really depends on on what the actual provision is. We would love to see things in the CC&Rs like minimum lease terms and the business use and the nuisance. We'd like to see those in the CC&Rs. The answer is whatever you want to make it harder to change, you put it in the CC&Rs, because changing the CC&Rs takes a vote of the membership, which if you've ever had to do it, and I've done it a few times, it takes a while. So you want to put something in the CC&Rs that you don't want another board to come along and change. But certain things are appropriate in the rules and regulations. The fines we talked about, the amount of fines, you certainly want those in the rules and regulations because you want to be able to change them without having to go through a vote of the membership. Certain things like, assessing for the compliance costs, we'd like to see that in the CC&R. So it's kind of a judgment call. It depends on the regulation. I will say too, get it in however you can. I had one community that tried to do a CC&R amendment to put in a minimum lease term of 30 days. They didn't have one. They didn't have any, and they had a lot of short-term rentals going on. 67% voted in favor of it, but they needed 75%, and everyone voted. So they couldn't get it done with a CC&R amendment, so they did it as a rule. And even though they got a repeal of the rule, 5% of the owners could call a special meeting to try to repeal the rule, it actually, they did not get enough votes to repeal the rule. So they have it in as a rule, not as a CC&R amendment. I'd still love to see it as a CC&R amendment, but it works, and it's been in place for, I think, over a year now as a rule.
Okay.
So.
Other questions? Deborah.
Nice to have you here, Laurie.
Thank you.
I
to be
know,
here.
wonderful. I know you mentioned having a flexible enforcement policy, but could you give us some ideas about the enforcement procedure
Yeah, so
specifically?
yeah, well, so enforcement procedures, the ones I've seen are typically you send a first notice is a courtesy notice. Second notice might be a hearing with the first level of fine, then maybe another hearing and a second level of fine. And I say this, I think for short-term rentals and also across the board generally, remember fining is not a profit making. It's not a revenue source for the association. The intent is to change the behavior. And if you've already sent them a courtesy notice and you've called them in and you fined them once, and you've even called them in and fined them again, and the behavior isn't changing, that's not going to change the behavior. I think what will change the behavior is stepping up that enforcement, letting them know you mean business. So maybe after either the first fine or the second fine and they haven't complied, maybe you send it to legal, and maybe they get that letter from legal. And then you go to alternative dispute resolution, and then you file a lawsuit. Now, again, you want to have that enforcement policy say, though, that the board has the right to choose which step to take first. And so some of these short-term rentals, if you want to nip it in the bud, you skip the courtesy notice, you skip the first fine, and you have that cease and desist letter coming from legal. Whether or not you actually charge them for that letter, you can decide. If it changes their behavior, I would probably say no. If it doesn't change their behavior, you've already set up at this point to maybe the next step is an internal dispute resolution meeting or an alternative dispute resolution. So again, I have clients that come to me and they'll say, we've been doing the daily fine. I am not a fan of daily fines or reoccurring fines. We've been doing it for 2 years. And I say, 2 years? Remember, fining is not a revenue source. You're supposed to be trying to change the behavior. If after the first fine, they didn't change their behavior, don't waste your time. Get legal involved. Send a strong message.
Other questions?
If we create a separate enforcement and fine schedule just for short-term rentals, are we going to get in any trouble with the Department of Fair Housing? Since we're targeting just renters.
Not that as long as it's not discriminatory, I don't think so. Fair and FHA actually to get FHA certification, they want to see that communities are enforcing a 30-day minimum lease provision or longer. So FHA certainly supports not having short-term rentals in your communities. So, I don't know that it has to actually be a separate policy, but maybe I've seen enforcement policies where certain violations are at a different level of fining, maybe parking violations because they're so common, they have different levels of fining. That's what I'm anticipating with your enforcement policy with the short-term rentals. You would just include a different fine schedule for that particular violation.
All right. Another question? Yes, Johnny.
One of my homeowner officers has a link to an ad listing a unit for short-term rental. Is that enough?
The board member has sent.
Right. They're like they told me I've seen a listing for that, and they actually printed it out for me.
Okay. Yeah. If you as the manager get the link to the short-term, the website listing, like I said before, you want to print it out. And I wouldn't rely on them. Sometimes I see these screenshots that literally come up like this big. You can't read those. Think about if it's going to court. You want it to go to court. So I say, as the manager, you get that link, you print it out, you take screenshots from your computer, not your phone, and you print those out, and you have a record of it was posted on this day in its entirety. And again, print everything. Print the pictures. I have one, the 2-year tenant that we think is the one short-term renting. They actually had a picture of somebody else's front door, and that owner kept getting people knocking on their front door saying, hey, is this the rental? They were not happy about it. But other pictures in that listing were the patio of the unit in question with the patio furniture. So that's how we could tie it to which unit it was. So all those things, every single thing on that listing is important. It's important that you print it out and you have a copy of it before you send the letter.
Okay. Any more questions? Yes. Lottie?
At which point of the enforcement process would the board members and neighbors have to testify, come forward with their testimonies? It's usually a very sensitive issue because they're all neighbors and live in the same development. And so when is that necessary?
You know, it is a sensitive issue, and a lot of neighbors say, you know, they issue a complaint, but they don't want to get involved. I think through beginning enforcement proceedings, certainly through courtesy notice, through maybe a hearing or a fine, even internal dispute resolution or alternative dispute resolution, you might be able to get away without sharing who the complainers are, or reporting entities of people are. But once it goes to lawsuit, you do have to let those neighbors know. And I actually would tell those neighbors up front, there is a chance. We'll keep your name out of it as long as we can, but there is a chance, depending on how far we have to take this, that your identity may become known and you may have to even testify in court. If they're that fed up, I understand they want to be anonymous, but if they're that, you can't have it both ways. You can't complain to the association, do something, but not be willing to testify. Because often those are the people who have the knowledge of the short-term renters. They have the evidence of the people coming and going. It may not be the board members. It's certainly not going to be the managers. How many of you are out there doing a stakeout? No, it's not happening. So I think being upfront with them, we will keep you out of it as long as we can, but at some point, you may have to testify, and you may have to be involved. And some owners might actually want to know earlier than that. And while we try to say they can't, to some extent, they might be entitled to know who complained against them at some point.
Any other questions? Well, Laurie Poole, we want to thank you for your clarity, your practicality, and also your brevity. Let's give her a big hand.